Welcome to Thursfields Talk Legal, a vidcast series from one of the leading law firms in the Midlands. I'm Steve Dyson, a journalist who's talking to a range of solicitors here at Thursfields on legal topics of wide interest to the public or businesses. Today's episode is all about wealth protection for business owners, directors and senior executives. And I'm going to talk to two lawyers at Thursfields to cover some very different perspectives in detail. In a while, I'll speak to Laura Williams, an Associate Director in Wealth Protection and Family Law. But first, joining me online is Ian Bond, Head of Wills and Estates here at Thursfields. Hello to you, Ian.
Hi, Steve. Good to speak with you again.
Good to speak to you too. Ian, we're here to talk about wealth protection for business owners, directors and senior executives. In a nutshell, this is where things have gone well for mum and dad, who've accumulated various assets, properties and perhaps an ongoing profitable business. But what happens when someone dies? I mean, this is a simple matter of making sure you've got a clear will, isn't it?
Yes, it is, but it's not that alone. There should be some more careful thinking about what needs to go into this. If a business owner fails to make a will and so dies intestate, they won't be able to ensure that the value of their business interests that they've accumulated over time passes to their intended recipients. In a will, steps can be taken to ensure that the ownership and control of the business passes to the co-owners, but it's also appropriate to look at whether the spouse and children have a seat at the table and make decisions about the business. Should the business continue to be within the family, either directly or indirectly through a trust? And who should have the responsibility of running that business? It may be that it's something that the family and the next generation are not considering that they want to be part of. So where there are a family business and some people are working within that business and some people aren't, it's about making decisions about which children are going to be coming into that business and what's their intentions about the shareholdings that they will have. And if there's property, some of them may disagree about what's going to happen with those properties. So it's important for the parents to make sure that their wishes are clear. Otherwise, you'll end up with a really messy scenario where there's a lot of conflict involved. And the whole point of having a will in place is to make sure you avoid the conflict. So making your plans crystal clear and involving the potential split of assets.
That makes a lot of sense. I mean, what you're suggesting, Ian, is a very detailed will, isn't it? With everyone understanding who gets what or who plays what roles in any company.
Yes, that's right. It's really detailed. You have to translate those plans into a clear strategy about what is going to happen. So it's not all about the wills. There may be trusts involved as well, making sure that the children are involved right from the outset about the ownership of the property, the ownership of the company, who inherits what. So there's no nasty surprises waiting for them. And with a company, they have to decide the plans of division of the shares, making sure everybody's entitled to inheritance without preventing the business from carrying on trading into the future.
It's all sound advice, Ian, and taking those steps will certainly mean that everything's well and good for mum, dad and their children. What I want to explore next is what happens when there might be a potential situation, divorce, or even plural divorces in the family, and you're now dealing with a scenario involving divorced parents, former sons-in-law and daughters-in-law, and potentially their children. Joining me online to discuss this family aspect of the law is Laura Williams, an Associate Director in Wealth Protection and Family Law here at Thursfields.
Hi Steve, thanks very much for having me.
No problems. Laura, we've been talking about wealth protection for business owners, directors and senior executives, and Ian Bond has approached this from a wills and estates perspective. But what happens where a family's been split by divorce or even divorces and separations? How can wealth still be protected and inherited properly in this scenario?
Yeah, the answer really is just to try and pre-plan and cover off the what ifs as early as possible. This, of course, can be quite hard to do as people in the honeymoon period or early stages of a relationship often don't want to think about the what ifs and about the relationship not working out. A bit like, I suppose, they don't really want to think about death either. But it is extremely important, particularly when there is pre-acquired wealth, children from a previous relationship, or family wealth and businesses that need to be protected. I tend to say to clients to think about it exactly as you would a will. You hope that you won't have to deal with it or look at the document, certainly anytime soon, and hopefully in this case, never. but it's there if you need it, and it avoids at least some of the inevitable conflict and expense later on. So there are various ways in which you can do this. For married couples, really, it's the case of entering into a pre or post-nuptial agreement. Pre-nuptial agreements are better, as obviously you're not married at the time that you enter into the agreement. And once you are married, the individual's entitlements to the other's assets changes automatically. So it is really important to try and cover off any agreement pre-marriage, but the option is there to do it post-marriage as well if necessary.
That all sounds sensible, Laura. It's 2021, of course, and not everyone gets married these days. What happens when a couple are living together and they have children? A premarital agreement can't cover them, can it?
For unmarried couples, we advise for them to consider cohabitation agreements and declarations of trust. So in the case of married couples, or a pre or post-nuptial agreement can set out what each party intends to happen to particular assets upon divorce. So for instance, you can ring-fence inherited wealth or claims on a family business. The prenup does need to be balanced, and it at least needs to meet each party's needs. That's very important. There are also some other requirements in terms of fairness and timing that need to be ticked before they will be held as valid. But they are certainly an efficient way of pre-planning who will be entitled to what at the outset. This obviously not only brings certainty to the parties, but also to the wider family members, i.e. parents who wish for their child to inherit, but do not necessarily want it passing to an in-law should things not go to plan. Without this, upon divorce, to put it crudely, all assets owned by either party or in which either party has even an interest are up for grabs, so to speak, and are likely to be argued over in costly financial proceedings. So as long as these agreements are drafted in the correct way and meet fairness and time limit requirements, courts are more likely than not to uphold the provisions, even if one party changes their mind later on. This can be particularly important for parents when they need to speak to their children about the need for a prenuptial cohabitation agreement before they marry or live with somebody, particularly if they are conscious that they wish to protect the wealth that they have worked hard to achieve and wish for it to go to their children and grandchildren as they choose.
Finally, Laura, what's your top tip or tips for families looking into this?
It's really to think for yourself and for your children in advance and stress the importance to them. It may not be something that they want to think about at the moment, but always think about the what ifs. People can't be forced into anything, but if these things are discussed and thought about at the outset, often people want to be fairer to each other as opposed to when they're angry or going through a separation, and a lot of the worry and uncertainty is taken away. These are really an efficient way of dealing with that.
Going back to Ian Bond with the same final question. Ian, what's your top tip from a wills and estates perspective for people to consider with wealth protection in mind?
Well, for me, the choice of executors is crucial. If there's a cross-option agreement in place for the shareholders, if there's plans in place, the executors are going to be the ones that are negotiating for the family. They have an important role to play if it's about the selling of the business. If there's no sale of the business, it's about running the business, and they've got to have the relevant business skills to make sure that they can go on in the short, medium and long-term basis. So having the right choice of executors for the family is crucial.
Ian Bond, Head of Wills and Estates, and Laura Williams, an Associate Director in Wealth Protection and Family Law. Many thanks to you both for joining us on Thursfields Talk Legal.
Thank you, Steve.
Thanks, Steve. See you soon.
Hopefully what Ian and Laura had to say about wealth protection for business owners, directors and senior executives is something people will find useful. If anyone wants any further advice, Ian is available on ibond@thursfields.co.uk or on 01217964027, and Laura is available at lwilliams@thursfields.co.uk or 01905 730 476. We'll be back soon to talk to more legal experts here at Thursfields about other interesting aspects of the legal world. Thursfields Talk Legal. Thanks for listening.